All right, my people, welcome back. Struggle for Yoruba nation validated by Oyo court. All right, my people, the news in details. Well, onto this, a declaration was reportedly made by Justice Ladiran of the Oyo State High Court on Friday, and that the passionate struggle and the campaigns for the recovery of Yoruba nation for the Yoruba-speaking people of Nigeria is legal and a fundamental human right. Given his verdict on the suit brought before the court by Sunday Adeyemo, popularly known as Sunday Igboho. All right, and then onto this, the judgment said, relying on domestic and international law, that every Nigerian, including the complainant, has the inalienable right to canvass for self-determination. The court also awarded the sum of 20 billion naira against the federal government and to the advantage of Igboho, whose house got raided in the dead of the night on the 1st July 2021. The respondents in the case are the Attorney General of the Federation, Director of SSS, including the Department of State Services DSS. The court granted all reliefs sought by Igboho and through Yomi Aliyu San. Reliefs include a declaration that the federal government's resolve to prevent him from propagating his belief in Yoruba nation in association with others was against his fundamental right to freedom of thought, conscience, and an association. Specifically, Igboho asked the court to declare that he and his Yoruba indigenous people had unquestionable and inalienable fundamental right to peacefully campaign and seek self-determination of Yoruba tribe in Nigeria and lobby the legislature to amend the CFRN 1999 as guaranteed by Article 20 of African Charter on Human and People's Rights Ratification and Enforcement Act laws of the Federation 2010 and then Articles 3, 4, 7 and 18 of the United Nations Declaration on the Rights of the Indigenous People made at its 107th plenary meeting of Thursday, 13th September 2007, thereby insulating campaign for self-determination from criminal culpability. Other reliefs sought by Igboho are a declaration that the respondent resolve in preventing the applicant from propagating his belief in association with other like minds in creating a Yoruba nation and or Ojujua Republic for his indigenous Yoruba people and hunting him with gun with a view to arresting him dead or alive when he had not called for war in achieving same was against his fundamental right to freedom of thought, conscience, and association, since campaign for self-determination is recognized by Nigerian law and international treaties of organizations to which Nigeria belongs. Declaration that apart from violating the fundamental rights of the applicant to fair hearing, it is unequitable and unfair for the second and third respondents to exhibit guns, ammunition, and other dangerous weapons and incriminating documents in public and claim that same belong to the applicant when their officers in actual fact shot their way into the house of the applicant situate lying and being at Igboho Villa, 1 Dalak Street off Soka bus stop, Soka area of Lagos-Ibadan Expressway, Ibadan, without subjecting themselves and their convoy of vehicles to prior search by the applicant, who neither signed any inventory nor search warrant containing inventory to that effect. A declaration that the media trial of the applicant by the second and third respondents in exhibiting prohibited and then or illegal items as applicants before the press and live television is usurpation of judicial power reserved by CFRN 1999 for court and violently violates the fundamental right of the applicant to be presumed innocent until proven guilty by a court of law recognized the said constitution and then properly constituted for that purpose. All right, a declaration that invading and or blocking the assets of the applicant and putting no debit order on his bank account is a violation of his fundamental right to own property and wealth guaranteed by CFRN 1999 and Article 21 of African Charter on Human and People's Rights Ratification and Enforcement Act Laws of Federation 2010. An order of injunction restraining the respondents, their agents, privies, and associates in other security forces and or anybody acting on their behalf and or instructions from arresting, detaining, molesting, harassing, and or in any way interfering with his right to personal liberty, freedom of movement, and peaceful enjoyment of his property without fear of the invasion of his home by the respondent. Igboho also prayed the court to compel the respondents jointly and then severally to pay him 500 billion naira, made up of the sum of 500 million as special damages for the damage done by his car and residence at Soka, Ibadan, and the sum of 500 billion naira being exemplary and or aggravated damages for malicious invasion of his Soka residence. He also implored the court to declare that the damage of his property was a violation of his fundamental right to peacefully own property and wealth as well. On the invasion of the home of the activist, the court held that the applicant led credible and unchallenged evidence against the respondent. The respondent did not deny the invasion of the applicant's residence. Rather, they admitted the invasion on mere allegation of suspicion. Well, suspicion cannot take the place of law, no matter how strong it is. The ugly show of crude firepower by the respondents or their agents leaving deaths, carnage, and destruction behind should be condemned. Well, the court further held that the invasion of Igboho's residence in the middle of the night without a warrant violated his fundamental human right to property, life, and family under Section 35I A to C of the 1999 Constitution. In the absence of any evidence that Nigeria is in a state of war, the action and overzealous conduct of the agents of the second and third respondents should be condemned in strongest possible terms. If the identities of the agents of the second and third respondents were known, they would have been made liable for their action, the judge said. Justice Akintola further held that the second and third respondents were silent on how the arms and ammunition allegedly paraded in Abuja were recovered from Igboho's residence, noting that it is difficult to believe that the arms and ammunition were recovered from his residence because there is no evidence to that effect. Meanwhile, Justice Akintola added that the judgment will serve as a lesson to government agencies who are fond of infringing on the fundamental human rights of citizens, and further awarded 2 million naira at cost to Igboho in his reaction after the judgment. Igboho's counsel Aliyu San said the judgment was a victory for democracy and the rule of law, adding that it had further proved that the court is the last hope of common man. All right, my people, well, this is what it is. On to this one, a lot have been said. Good one. Well, my people, that has been it on this one. What more can we say? Meanwhile, let me have more take from you on this, and remember to subscribe for more updates if you have not subscribed to this channel. Thanks always.